This is where we are. So today's speaker is a man that I have admired and really loved for a long time. He is my next door neighbor for over 25 years. He is a very well decorated attorney. He's served in a lot of capacities in the various boards that attorneys serve on in the state of Michigan. He could tell you more about that, but he is one of the most interesting people I know. I really love his attitude. I love where he's coming from. I think he's a great person, and so it's really an honor for me to get to introduce my friend, my neighbor, Larry Bennett, who is going to come and speak on the Supreme Court for us today. Thanks for being here, Larry.
Well, I wish I was half of what Marty said. And I wish my grandchildren felt that way. So Marty approached me about doing this and thought that talking about the Supreme Court might be of interest to at least some of you. And you know, it's been widely discussed that the public is losing confidence in the United States Supreme Court. So the question is why and how did we get there? So I'm going to talk about that for the next few minutes. The court was originally designed to be an independent branch of the government to serve as part of the checks and balances, which we all heard about through school a long time ago. But it's actually a very practical and necessary part of the functioning of the government, is to serve as a check and a balance against the political positions of the presidency and Congress. Until recently, the court was revered for its integrity, even when it issued controversial decisions that half the country disagreed with. Its integrity was never questioned. That has changed. Public trust in the court as a neutral arbiter has been declining sharply and is now at an all-time low by a lot. Why? Because I think the answer generally is many Americans now see it as deeply political. Not just in its rulings, but in how the justices are nominated, confirmed, and even how they behave on and off the bench. More than the perception that they are deeply political, what's troubling to me is that people now see them as having no more integrity than politicians. And we all know the general feeling about the integrity of politicians. That's a sea change from when I went to law school in the 70s, when the Supreme Court was held above all of that, was considered brilliant, independent, and the very antithesis of corrupt. Let's unpack how we got there. The idealistic view is that the court should be completely apolitical. That has never been the case. In the early days of the Republic, as the framers of the new government labored to translate into practice their idealistic views and the theoretical governing foundations they outlined in the Constitution, the Supreme Court was not understood to be removed from politics. I did some research on this to see how it was perceived back in the 18th century and the 19th century, and I was surprised to learn something. The first Chief Justice, John Jay, served as a close political and legal advisor to George Washington. He also served simultaneously on the court and as ambassador to Great Britain, in which capacity he negotiated 2 different peace treaties. John Marshall, the Chief Justice who famously decided that judicial review belonged to the Supreme Court, the ability to review laws, a right which was not set forth in the Constitution, was active in Federalist politics, both nationally and in his home state of Virginia, throughout the entire time that he served on the bench. Some of the judges during that period of time were politicians, and many of them remained close to their presidents, who appointed them in ways that would not be acceptable today. In the 1800s, Chief Justice Roger Taney continued to serve as a close advisor to Andrew Jackson. David Davis, Lincoln's close friend and campaign manager in 1860, acted as an advisor to the president, Louis Brandeis, and I'm giving you some names of justices that are quite well renowned. Brandeis remained a close advisor to Woodrow Wilson. William Howard Taft, a former president who was appointed Chief Justice in 2012, freely and openly advised Harding, Coolidge, and Hoover. Franklin Roosevelt continued to rely on Felix Frankfurter long after Frankfurter was appointed. It gets more interesting as we get into the mid-1900s. Abe Fortas was on the Supreme Court, and he was very good friends with LBJ. When a civil rights matter came up before Congress and was passed and was sitting on LBJ's desk, the FBI was supporting it being passed. The White House staff said, no, we don't think it should be passed. LBJ turned to Fortas, and Fortas said, I don't think you should pass it. I don't think it'll pass muster. And Fortas wrote the veto message that LBJ delivered verbatim. There's an interesting note that I came across that we can relate to. Harry McPherson, one of the political aides at the time, walked into the White House on July 24th, 1967, when the Detroit riot was happening, and found Fortas with the president preparing the draft that the president was going to give on television, where Johnson would announce the deployment of the military personnel to restore order. So Fortas, sitting on the Supreme Court, is helping draft a speech about what the president could do and what he should do with respect to what happened in our city. Many of you may recall Fortas didn't last long on the Supreme Court. Republicans and Southern Democrats quashed his nomination as Chief Justice, largely out of opposition to his liberalism and Jewish heritage. But Fortas gave him some ammunition as well. He did business with a Wall Street banker who later came under federal indictment, and Fortas was getting a $20,000 annual retainer for life from this soon-to-be-found criminal. This wound up making Fortas face the realization that he was likely to be impeached. And I think it's important to bear in mind this example. He was getting just an advisor fee, and he faced impeachment and resigned. And I'm going to connect that to what's been going on with Thomas and Alito later. So today we find our Supreme Court populated by law professors and jurists. There's no longer any politicians. Sandra Day O'Connor was the last elected official that was nominated to the Supreme Court. Despite the fact that we don't have actual politicians being put on the bench, we still find that the Supreme Court is consumed with political issues. So it starts with the fact that they're nominated by the president and confirmed by the Senate. Both are elected partisan bodies. And that process alone makes it a political issue. But that's always been the case. So that alone doesn't explain why we now have this perception that the Supreme Court is nothing more than political. So what seems to be different is how combative the confirmation process has become. They definitely come across as battles of ideology. Just think of how the confirmations of Brett Kavanaugh, Amy Coney Barrett, or even earlier Clarence Thomas became national spectacles. Senators now vote almost entirely along party lines. The process often centers not on qualifications, but how a nominee might rule on key political issues: abortion, guns, voting rights. This is very distinct from as soon ago as 1993, and I tried to find the video because I was struck by this back at the time it happened. Orrin Hatch would be what I think most of us would consider, most of us on the left would consider a sane Republican. Somebody who you disagree with but can respect. Ruth Bader Ginsburg was nominated. He was on the Judiciary Committee, and I really would like to have shown this. I just couldn't find a clip that I could play, but I'm going to read you what he said. A president is entitled to some deference in the selection of a Supreme Court justice. President Clinton and I are unlikely to agree on the person who ought to be nominated. But so long as the nominee is experienced in the law, intelligent, of good character and temperament, and gives clear and convincing evidence of understanding the proper role of the judiciary and our system of government, I can support that nomination and that nominee. Moreover, I do not expect to agree with any nominee, especially one chosen by a president of the other party, on every issue before the judicial branch. The key question is whether the nominee can put aside his or her own policy preferences and interpret the Constitution and the laws in a neutral fashion. Finally, I would point out that I disagree very much with some of Judge Ginsburg's academic writings and some views she held prior to ascending to the bench in 1980. I believe that Judge Ginsburg's judicial opinions, however, indicate her understanding that her policy views and her earlier role as advocate are distinct from her role as a judge. Now, Mr. Chairman, I want to say that I am pleased with this nomination. Can you imagine that being said today? I mean, wouldn't it be wonderful? But I don't think we're going to see it anytime soon. So there's that whole confirmation process that's become so much more antagonistic. A second change is that there have been several major political decisions in this environment. We've got Bush versus Gore, which effectively decided a presidential election. Citizens United, which opened the floodgates for money in politics. Shelby County versus Holder, which gutted the Voting Rights Act. Dobbs v. Jackson, which overturned Roe v. Wade. And Rucho versus Common Cause, which called gerrymandering a political issue, and thus it can't be touched by the Supreme Court. The Dobbs case almost perfectly shows the combination of politics and the confirmation process. I found a quote from Leah Lippman, a professor at UM Law School, speaking at Harvard, and she simplified this issue. She said, people do not need to be legal experts to understand the political nature of appointments to the Supreme Court. The sequence of a campaign promising to overturn Roe, followed by the appointments of justices who ultimately did so, answers the question of whether the process is political. The third change that I think contributes to the low standing of the court are several instances of behaviors that do not meet the norm of the regard we want to hold our justices in. There's the sex-related issues of Thomas and Kavanaugh. There's undisclosed gifts of substantial amounts of money of people that are intrinsically involved in the political machinations of Congress and the presidency. Thomas reportedly accepted and failed to disclose numerous gifts from a Republican mega-donor and real estate magnate, Harlan Crow, over 2 decades. These gifts included luxury vacations on a super yacht and a private jet, as well as private school tuition for a relative. In 2014, Crow purchased 3 properties from Thomas and his family, including the home where Thomas's mother lived. The transaction was not disclosed. All the while, Crow has cases or legislation pending that he's trying to advance. The Senate Judiciary reported that Thomas should have recused himself from cases related to Donald Trump and the 2020 election due to his wife, Ginny Thomas's political activities and support of the stolen election argument. Thomas felt no compunction to keep himself out of cases that his wife had an interest in. And there was nothing anybody can do about it. Alito also has serious issues. There was recently the report about his wife, allegedly his wife and not him, flying the flag upside down. He went on a luxury fishing trip on a private jet owned by a hedge fund manager, a Republican donor. He didn't disclose the trip. And his impartiality was questioned because the donor, hedge fund, had cases pending in front of the Supreme Court that Alito did not only disqualify himself, didn't even disclose. There also is substantial evidence that he leaked the Hobby Lobby decision before it was published to a friend who supported that. The Hobby Lobby case said a small corporation has religious beliefs that are opposed to contraception. They do not have to provide contraception as part of the medical care. So despite its protestations of impartiality, the court stubbornly and intractably refuses to be bound by the ethical rules that all the other do things no other federal judge is allowed to do. In response to some pressure, they did pass their first ever formal code of conduct in November of 23. However, it did not go nearly far enough. Legal experts, watchdog groups, legal scholars, people on both sides of the aisle noted that the code relied on self-enforcement by the justices. If they don't have integrity, what good is self-enforcement? It lacked external enforcement mechanisms in case the justice did not act. And again, is far weaker than the ethical rules that apply to all of the other federal judges. An additional factor is that, oddly, the major constitutional way we want to give the justices independence, like tenure, actually injects politics on the back end, because they make strategic decisions about when to retire so that they can be replaced by someone ideologically similar. This was a quote I took off the internet because I thought it was apt. You can have these justices operating in perfectly good faith, but nonetheless, they are guided missiles who will, for legal reasons, execute a political agenda. And the politics gets rewarded. Ruth Bader Ginsburg didn't resign, despite multiple requests that she resign while Obama was president because of her age and her failing health. She felt it was wrong. We know what happened. She died just in time for McConnell to squeeze somebody through. Stephen Breyer didn't follow Ruth Bader Ginsburg. He resigned so that Biden was able to appoint somebody. Anthony Kennedy, who I think was a very well-respected justice. He was a conservative, but he was within the margins. He wasn't wildly in support of extreme Republican agendas. But he, too, resigned so that Trump could, it was either Trump or Bush, probably Trump. This has gone on routinely in the past. It's nothing new that justices time their resignations. But I think in part, everything's under a microscope now. Everything is subject to skepticism. And we've got so much more play in social media, the 24-hour news cycle, so everything seems to be magnified. So I think those things have combined. You've got extremists on the bench making extremist decisions. They're activists. They have exhibited conduct which in the past has resulted in resignations or threats of impeachment, i.e. Fortis. And they're doing nothing. John Roberts seems to have lost control of the court. So I think those are the factors that have combined to make the U.S. Supreme Court viewed as nothing other than a third branch of politics. And it's really significant that they have lost the confidence of the country and have become so biased in their decisions. They don't have the ability to enforce their decisions. Their decisions used to be followed because that's what you did. Even if you disagreed, you followed what the Supreme Court said. Now we have a president who's threatening to not follow decisions he doesn't like. And I think we have a country filled with people that are saying, we'll wait and see how they rule. If we like it, we'll follow it. If they don't give us a decision we like, we don't have to follow it. They're nothing more than political apps anyway. The other effect this has, and this has real life meaning, is the organizations that file suits to vindicate civil rights, whether it be voting rights, false arrests, other constitutional invasions, are reluctant to bring cases to protect us, because while we may win in lower courts, even in front of Republican judges, and even win in courts of appeals, even in front of what we would consider to be unfriendly venues, they're afraid the Supreme Court's going to reach out and gut the protections that still exist. So we're not going to see such things as in cases brought about voter suppression. There's other aspects of it that affect our daily lives. Cases involving dangerous products, cases involving environmental contamination, things that affect our day-to-day lives. Those cases are going to not be brought or not be brought in circumstances where they were brought in the past. So it's not just, well, okay, the politics, this too shall pass 28, hopefully brings a better environment. There's going to be long-lasting consequences of this. One thing that has received extreme criticism is the use of the shadow docket. In the shadow docket, these judges get to make decisions without giving any of their reasoning. And judges always bring their philosophical biases and meanings to the court and to their decisions. As long as they stay within the margins, the pendulum will generally swing back and forth without causing a great deal of harm. There'll be some unhappiness on some decisions, but eventually all these things even out. But when the biases go to the extreme and there's no guardrails, there's no sunshine on this, things become much more critical. And I actually have an example to give. I was in the Supreme Court in the early 80s. I did civil rights work at the time. And the issue was, what process is due a prisoner who is going to be put in administrative segregation? This was a big issue in prison management, because prisoners don't have a lot. When they get put in administrative segregation, they have nothing. And there's all kinds of harms that come from that isolation. But that wasn't the issue. The issue was, before you put them in, what kind of hearing is the inmate entitled to? You know, is it a full-blown criminal trial? Is it just an administrative hearing? Who gets to make the decision? All those issues. This particular case, the inmate was accused of killing the guard. And the hearing was a kangaroo court. It had matriculated its way through the federal district court and the Court of Appeals, and the last decision of the Court of Appeals was certain process was due. And during the argument, there was a great deal of discussion about what rights the prisoner had to keep the meager things that they had, things like getting exercise, having a TV, a book, and so on and so forth. And I don't, has anybody here been to the U.S. Supreme Court? So the podium is not very far away from the bench. It's pretty small. I'm going to say that we were as close to Chief Justice Berger as I am to you. It's that close. Now, there's some seating behind, but there's not a lot of space between the podium. And I could see Berger getting better and better and better. And at one point, he leaps out of his seat and he says, "What about the rights of the widow?" So that's a significant issue. I get it. But it has nothing to do with what the answer is as to what process has to be followed before you take all these things away from the prisoner. It is completely legally irrelevant. And Justice, it was hard to come up with an answer to that, because it's the Chief Justice, and it's like you can't tell the Chief Justice, "Judge, that's irrelevant. You just can't do it." And I'll never forget this, Justice Stevens jumps in and says, well, I think what Justice Berger, or Chief Justice Berger means is, what are all of the considerations that go into what kind of process is due? Is there prison administration issues and so on? And he saved the day. And I wanted to give you that example because it's a real life example of the Supreme Court. But what it relates to is, in open court, when you're having this argument, irrelevant views of a justice or biased views of a justice get exposed and controlled by the other justices. When you have the shadow docket, we don't know why they ruled. Sometimes we don't even know who ruled unless we get a dissent, which we've been getting a lot of. The other thing is it's very disruptive to the lower courts. The lower courts have been complaining about the shadow docket because they're not getting guidance. They have to follow the Supreme Court opinion. But if they don't know what the reasoning was, it's hard for them to then apply it in the real world setting. And this is a real defect that Roberts is allowed to mushroom. It's used much more now. Why? I don't know. He won't explain why. But it's very unnatural that it seems like every time Trump disagrees with something, he gets the Supreme Court to hear it. And his success rate is nearly 100%. Why? Why is that happening now and it's never happened before? Whether it is the right thing or not, greater minds will eventually analyze that in a few years, but it doesn't add to the confidence that people have in the Supreme Court. So, what are we going to do? There have been efforts in the past to pack the court. FDR famously tried to pack the court with additional justices because he didn't like the way the Supreme Court was ruling on his New Deal legislation. And of course, getting ready for this, I found out Lincoln did the same thing. He was unhappy with the Dred Scott decision, which that decision said black people are not people. They have no rights. They are property. That drove him crazy. It did in most things. But he wanted to increase it to 10 justices, and he couldn't get it through. So it was resisted by both parties as having a negative impact on the perceived impartiality of the court. We are the only country with lifetime appointments of the judicial officials. There are a few third world countries, Haiti being one of them, Oman being another, and there's a third. But that's it. All of the other substantial democracies do not have lifetime appointments for their judges. So there's a number of proposals that are seeking to come up with a fair way to resolve that issue. You certainly can't do anything with the current justices. But my favorite proposal is the one that is floated by a lot of legal scholars that would change to a fixed term of 18 years, and each president gets 2 nominations every 4 years. That way, it constantly rotates. They don't have their lifetime appointments that they can then manipulate for when they decide to get more lifetime people up there of a particular persuasion. And I think you would wind up with A, a more balanced court, and B, a court that is perceived as more neutral. That's all I got to say, and I'm happy to hear your thoughts.
I think the whole Supreme Court needs to be reviewed. We don't have the transparency. It's an ancient Supreme Court. We're in a different era. We're in a different time. Humanity needs to make huge changes. There will be someday when those little kids out there, they'll look back and they'll go, what were they thinking back in those days? What were they doing? We need to look at all of the possibilities, even artificial intelligence. Bring it in. Tell us how to make the system work. Let's study other countries. Let's find a way to do it. Let's bring the people together to do this. What about a secular humanist Supreme Court? Someday, Gene Roddenberry had it right. There'll be a world there'll be a world federation where we all are government, well, the one system. But I think we need to rebuild. It's wrong. The system doesn't work. It's failing now. And you can't have the balance thing changing all the time. That's not going to work in the future.
Okay, thank you. That's a lot of good input. Did you have anything in there that you thought would be a good thing to respond to?
To that? Yeah.
I can talk on this for another couple hours.
Yeah, I know.
Talk on that.
But I want to humanist government. I want secular humanists. I want, if we can ever rid the world of religion, we have a chance.
Well, so you've identified one of the major issues in how our judiciary is supposed to address cases. They're supposed to interpret the law, and there are abundant rules and regulations as to how laws are to be interpreted, whether it's supposed to be presumed valid or presumed invalid, depending on which right you're talking about, which core privileges apply to some statutes so that they can't infringe on those privileges. And yet, you can't just make law based on written word. You do have to bring to bear its real world impact. So there's an everlasting tension between what the law is intended to accomplish and its impact on people. And that gets played with in every major case. What are the major policy considerations? And there's no way to eliminate the philosophical bent that each judge brings. I mean, when we file a case that has significant issues, we hold our breath till we find out what stamp gets put on our plea.
Larry, you mentioned impeachment of a justice as a potential term limiter. My first question is, like, how does that work? Is that a possibility? That mechanism already exists to be employed? Like, is that possible? And my second question would be, is there any hope? I know legal precedent, like once the Supreme Court rules on something, it seems like that's precedent going forward eternally into the future. But they have reversed some bad decisions that they've made in the past. And is there a way that corporate money being considered personal political money, will that ever be overturned? And will the new ruling that laws don't apply to presidential behavior, is there any chance that that can be reinstated?
So, I'll answer the impeachment question in a second. The longevity of an opinion is subject to the doctrine of stare decisis. You guys probably have heard that term. Once it's decided, it stays decided, unless something materially changes. You can't have one Supreme Court say, this is the way we interpret the law, and then 2 or 3 justices change down the road and they say, nah, we're going to decide that a little differently. Because then you would not have any stability, and that has its own negative features. It is a problem when we get a decision like Citizens United, which has had terrible effects, or this immunity decision, which has been renounced by most legal scholars. So, when is that going to get reversed? That's a very sensitive question, because a justice may say, I think it's a horrendous decision, but I have to respect stare decisis, or we're going to start going back and forth every time there's a presidential appointment. It's a thorny issue. But, Plessy v. Ferguson was reversed. Plessy v. Ferguson was in the 1890s. Brown versus Ford said we do have to have equal schools. It's not, Plessy v. Ferguson was separately equal, and Brown versus Ford got rid of that. It took 60 years to correct that. It took, 50 years to correct Roe, if you're looking at it from that perspective. That gives you an idea.
I think we have a couple questions over here.
Well, let me just answer this impeachment real quick.
Okay.
Am I operating on a time? I don't want to
We don't want to go too long, we're already a little over.
Oh, it's lunchtime.
Yeah.
I'm sorry.
I really want
Impeachment is a very rough, tough process. I mean, it's very political. If you don't have enough, it takes 2/3. If you don't have 2/3 of one party, it's just not gonna happen. Fortis, for whatever reason, back in the 60s, I think, we had kind of Dirksen, we had other people that on both sides that said, let's do the right thing, not the political thing. In today's environment, it's just not gonna happen. Hell, somebody said, let's storm the Capitol, and that guy couldn't get impeached. That's pretty extreme.
Okay, I think JD, you had a question?
There's a standard format for your intro, your method, analysis.
Peer review.
You mentioned the chat docket, you mentioned that there are concepts within that. There are things that judges are supposed to, concepts they're supposed to appeal to when interpreting the law. Is there something like the standard scientific format that the Supreme Court justices are supposed to be using or should be required to use? So they're basically showing their work and the math problem so that they can track their decision. Is there anything like that, or
No.
do you think there should be?
No, only their morality and collegiality. There are times that the judges meet and just, and actually change one or two minds, one or two votes. Doesn't happen much these days with the 6-3 imbalance, but there's no structure. The process is, from the 30,000-foot view, the process is the district court judges decide the case. Then it goes to 3 judges in the Court of Appeals, and sometimes the entire bench. It's called an en banc review, where the entire circuit hears the case. And from there, it goes to the Supreme Court. And by the time it gets to the Supreme Court, things should be synthesized down to specific issues, but there's no regimen that constrains what they do. They can make it up as they go and often do.
Okay. Please go ahead, you have a question.
Yeah, so I was wondering, for these potential solutions, like setting a term limit of 18 years, how does something like that implemented? Like who,
Impossibly a constitutional amendment. So the number of justices that sit on the Supreme Court is not in the Constitution. That's done by statute. But their term is for life, and that's in the Constitution. I think we can get a constitutional amendment in these days.
I think it's pretty tough.
Although they're getting close on it, people work. I mean, they actually.
They all have.
Yeah.
What can we do besides vote, protest, and petition to help in getting things rectified?
We gotta get the right people in office.
Right.
And that's the only answer.
I
And
just
get
feel
it
so-
recently done.
Yeah.
It's very frustrating. It's very frustrating to the people because they lost confidence in the court. It's going to have real world consequences on issues that people won't bring cases on. As lawyers, we grew up thinking, let's have an honest debate. Let's get an honest decision. And let's move the law forward. And it's like, when you know what the result's going to be before it's heard, that's just not good.
I think we have time for one more question. Anyone else? Yeah.
I wasn't able to see bits and pieces. I've been running back to childcare in here, but I feel like with the newest justices that were added in, there's been a lot of conversation around constitutional originalism as well, and that sort of interpretive lens. And it gets a little bit at the point I think you're talking about, the moralism of these shadow doctrines and some of the processes through which they're looking at the Constitution. And I feel like I've always seen this association between constitutional originalism and biblical literalism, and kind of the philosophical underpinnings of the majority of our country seem to align, and I think that there's an influencing factor there on who's selected within those interpretive lenses. So that might be a little bit of an answer to Lorelai's question too, is just changing hearts and minds and trying to get people to interpret them. This is the English major's answer, but trying to get people to interpret texts differently and to think differently about the way that we understand a written doctrine.
So this originalism is such a phony doctrine. They say if it's not in the Constitution, it didn't happen in 1776 or 1790s when the Constitution was passed, then it can't be a constitutional right. Therefore, it's subject to whatever legislation. I don't think they had machine guns in the 1790s, so why would that be included within the Second Amendment? Why can't we ban machine guns? We didn't have them then. Oh, no. Then we get to the broad impact of what the amendment was intended to do. So we get this, and that is not entirely new. That has gone on in the past because we've got different philosophies. But what's different now is this lack of confidence in the court for all these other reasons. And so that's the impact of the loss of legitimacy. But you've identified, actually some of these questions have identified the elbows that we have to deal with in the legal system, and there's no perfect answer. You rely on the integrity of the people in the process, and that's sort of that kind of stuff.
All right, let's thank our speaker.